Without further ado, let's get the lovely Michael Foran here. Here he is. Hurrah, everybody. Lovely to see you, Michael. And you must be absolutely exhausted, Michael, because this must just be a continuous. We were so pleased to be able to grab an hour and a bit of your time today. Thank
Oh,
you.
anytime at all. Yeah, I am exhausted. So if I fall asleep halfway through this, just, prod me, I'll wake up. It'll be fine.
We'll put off, I'll start playing the guitar, okay? Then you'll
Great. Perfect. That'll do it. Yeah.
We've got it. Oh, well, listen, you must be delighted because you've been vindicated from the very beginning when you started writing and not realizing the audience that you were going to get from this and the traction that your words were going to take. But uh, fabulous timing for
Yeah.
everything. First of all, the
It's
Scotland thing, and then leading into this. So,
I mean, yeah, it's been a fantastic kind of few years, I suppose. I mean, it's been a tough time for a lot of people as well, but I don't think we could have quite anticipated how strong the victory was going to be in this case. Like the ruling really was resounding. It was unanimous. It was clear. It was unequivocal. I think if I remember the last time that I was on here, we were talking in anticipation of the judgment. I said that I thought we were likely to win, or at least Forum in Scotland were likely to win. Um, and it feels great to be vindicated on that. These are complex, difficult legal arguments that the I think the Supreme Court demonstrated a real skill in getting to simplicity on the far side of that complexity.
mhm.
55 years of anti-discrimination law going right the way back to the first equal pay claims that were made, first legislation around that. And they wrote an extraordinarily detailed judgment, 88 pages, and it can be summarized in a few sentences. It's really impressive piece of work, I think.
The judgment, the 88 pages of the judgment itself, and as you said, it can be compressed to, just a few brief sentences. Do you think that they didn't do that, that they went to the 88 pages because they anticipated the kind of pushback that we're now seeing and wanted to try and circumvent some of that?
Yeah, I mean, I think part of it might be the anticipation of pushback. I would suggest that the primary motivation from the court was that they understood just how much public interest there was in this case. That this wasn't as if the audience of the judgment was just going to be the parties and occasionally the lawyers who practice in this area. I think they understood quite clearly that this judgment was going to be read by an awful lot of people who are not trained lawyers,
Mhm.
and they wanted to be comprehensive both in terms of clarity about what the judgment says. So they had this like summary at the end. They had a bunch of bullet points that they went through to say, this is a been a long judgment, but here are the key takeaways. Judgments don't normally have that. This is clear. I think it's clear that they were aware that this was going to have a wider reach than an ordinary judgment would. And I think they saw this as an opportunity to have a definitive word on this question. And so they wanted to be comprehensive. They didn't just say, because they could have, they absolutely could have just said, there's a very, very narrow question here about the representation of women on public boards. In order to answer that question, we have to answer this other question about the definition of sex. Here's the answer to that. It applies to there. There we go. But instead, they've said, this is an opportunity for us to write something definitive about this entire area of law stretching back 55 years. Yeah, I think they were clearly aware of the public interest. I wouldn't be surprised if they anticipated that there would be um, disagreement with the judgment or pushback from the judgment. And so they wanted to be as clear as they could. So they engaged with all of the arguments that were raised before them. And I think they did a really comprehensive job with it. So yeah, I agree. I think they were cognizant that this was not an ordinary or a normal judgment.
Well, they need lots of thank you cards WRN. Maybe we'll send them some badges for what they've done. I can see there's some questions going in the chat already, and I want everybody to have an opportunity to get their question asked. So we'll just do a couple more, and then I'll get Vicky to go through some of the questions that we've got, and we can come back as well on it. So if we can talk, please, about the pushback. And I think that's most concerning to us all. So we're writing and speaking. And, I think we've been on with Robin Moira White twice, both on Northern Ireland programmes, and also some professor from Queen's spouting the Windsor framework. So I know that you're not up to speed on that, but I'm hoping that you might have a look for us. But and of course, Robin Moira White on Women's Hour on Monday, talking about why it's got no legs, and they're going to go to the HRC. And I'm presuming all these organisations that are coming out in support of their trans buddies, employees, or whatever, have been told that there's nothing to do. They don't need to do anything because it's all going to be fixed. They're going to go to the European Court and they'll fix it. Is that your take? And what can we do? Well, other than just sit and wait. We're not women that want to sit about and wait. So what are the things?
No, I don't anticipate you are. Yeah, I mean, I think broadly, I'd say there's three ways we can categorize some of the responses that we might describe as pushback to the judgment. The first set of them are attempts to minimize the implications of the judgment, to say it's actually a really narrow judgment, it's only talking about this very narrow question. There's all this further stuff that has to be articulated or understood outside of that. And you see some of this is coming from some of this is even coming from lawyers, because they've read the judgment, and what they've not understood is how this judgment situates itself within the broader anti-discrimination law framework. And I think one of the things that's happening in that sphere is that there's effectively two ways that you can approach this question. There's kind of two defaults that you have for thinking about this judgment. The first is, if you operated from the presumption that the court is operating from, which is that biological sex is this real thing, it's a category that exists out there in the world, that our law recognizes in certain areas, that gender reassignment or gender recognition doesn't erase that from our law, that being protected under the protected characteristic of gender reassignment doesn't change your sex as a matter of that kind of physical reality, and it doesn't change your sex as a matter of law. It doesn't confer entitlements to use single-sex spaces intended for members of the opposite sex. Gender recognition certificates may or may not have some change to do with that, and that's the question the court's dealing with. If you approach the judgment from that perspective, this judgment's really clear. It doesn't bring a huge amount of confusion, because it's just a confirmation of all of that law that we've broadly been aware of already, and then a clarification of what you do with these gender recognition certificates. But most of the judges, or not judges, most of the lawyers or commentators that are minimizing the judgment approach it from this opposite perspective, where they think being protected under gender reassignment does confer this entitlement, or at least gives rise to the question that it might be unlawful discrimination to exclude a transgender person from spaces that they want to be in. And then this judgment is confusing in that sense, and then it's unclear what the judgment says about these spaces beyond saying that you're not entitled to use them. So they kind of give rise to this kind of separate question of okay, well, you're not entitled to use single-sex spaces intended for members of the opposite sex, but are you required to provide them on a basis of biological sex, or do you have discretion? Can you choose to adopt a trans-inclusive policy or something like that? So that's the first kind of category, where there's this kind of disconnect that's happening about the kind of background law, and it's resulting in some people minimizing the judgment. The other category, I think, is just misrepresentation about what the judgment says or what its implications are. And we've seen this. I mean, Stonewall said the judgment's not law yet, or we need to wait for guidance before we can go any further. And I think the judgment's not law yet is on the very extreme end of this, but the more kind of other variants of that are people saying the judgment is really unclear, so we have to wait for this guidance from the Equality and Human Rights Commission. So we can't do anything until we've got that guidance. And that's dangerous for employers and for duty bearers under the Equality Act, because the judgment is clear now, and it clarifies that this has been the law since the Equality Act came into force in 2010. So sitting around and doing nothing while you have potentially unlawful policies in operation creates a real risk for those organizations. And yet they seem to be operating from the presumption that they can just hang back until the guidance arrives. And I don't think that's necessarily a safe thing for them to be doing. And then the third category are people who are just like actively attempting to undermine the judiciary, the decision making of the judiciary, either on the extreme end, arguing that this is transphobic or bigoted or fascist or whatever insult you'd like to throw, and that the judiciary should be ashamed of themselves and blah blah blah. On the more moderate side, but still, I think, attempting to undermine the judgment, are these arguments that the court either failed to consider human rights arguments, which is not true, it clearly did, or that this judgment is going to be exposing the UK to a successful claim in the European Court of Human Rights. People can kind of take a case that way. And I don't think that's true either, but that's an attempt to kind of muddy the judgment. And on an extreme end, you see people saying, well, I'm going to ignore the judgment. I'm going to continue doing what I've been doing, and I don't care what the law says. So, there's a lot of different kinds of kind of pushback that we're seeing. And some of it, I think, more understandable than others. I think if you've not really been following the topic, and you approach what looks like a generalist solicitors that do employment law, and they've not been talking about this topic at all, and suddenly they've got things to say about it, and what they say is, maybe uninformed or misinformed, because this has become a really highly specialized area of law now. And there are some people who are coming along who don't have the hinterland of knowledge about the law in this area, which I would say, most of the women on this call are likely to have a better knowledge than some of these employment lawyers are, because you've been thinking about it and you've been immersed in it for years. And these people are coming along and they haven't been, and they're putting out guidance, and that's creating, I think probably legitimate confusion among some duty bearers, some employers. And, that's being, capitalized and seized upon by people who are trying to undermine the judgment as well. So all in all, I mean, it's been a really extraordinary reaction on that front. I don't think I was quite anticipating it to be as fractious as it's actually been. And maybe that was a bit naive of me, but, I'm a bit naive.
Well, I think we'd all guessed there was going to be pushback. I mean, I think there's a category of people that are never going to accept it and will always think that they were right and we were wrong. And then there's the category that have just gone along with it because they've been told that it was the thing to do. And it's those people that we need to reach. And I'd like to think most of them are kind of probably in councils writing policies, and they may not be the decision makers in the council, but they're somewhere in that chain, and providers making the policy, and hopefully they'll get there. It was good to see, we talked just before we came on, the NHS England have put out a good notice today, just so that everybody knows. They've said that they are going to go through all their policies and make sure they're compliant with the law. And their trans inclusion policy, I think it's called, is being marked under review, and they'll come to it after the end of the consultation and the outcome of that consultation from the EHRC. So they've been really clear, and they gave background to all their staff. So perhaps that also others might see it and might start leading the way when these bigger organisations, because I mean they're the biggest employer in the UK, aren't they?
Yeah, I mean, one of the things I think we've noticed is that an awful lot of private employers have shifted very quickly to adopt the judgment. They're erring on the side of caution of adopting the judgment. And it seems to be more public bodies that have been dragging their feet a little bit. And I think part of that might be that it's not their money that they're risking if there is liability.
Mhm.
And it might be that they're more inclined to be thinking about their role or their job as being more about social justice, whatever that means, than about profit and avoiding liability. But NHS England is a huge employer. It doesn't want to be dealing with the kind of claims that we are seeing in some of the NHS trusts and in some of the boards. But this judgment, I think, is the kind of judgment that sends a pretty clear signal about where the law is on that area.
Mhm.
So yeah, this can only be a good sign that they're taking the judgment seriously.
Yeah, and so what do you think? So, for instance, take London and the Mayor of London, who was given absolute silence from the letters that we've sent, and every single thing that emanates from there is covered in trans and all the policies. I think this is quite ridiculous and ludicrous, redefining the definition of women. What's it going to take, do you think, to turn that? Is it going to be somebody taking an action?
I think it's as with all of these things, I think it's going to take an awful lot of things happening at the same time. It's going to take political pressure. It's going to take pushback from within organizations. It might take the risk of litigation. It might take actual litigation. One of the things that I think we're seeing here is, yeah, and I think we saw this right after Forstater as well. It's almost as if we're right at the beginning of anti-discrimination law. Like when the first anti-discrimination laws came in about sex discrimination and race discrimination, the rules were pretty clear. You can't discriminate on the basis of race, for example. And you'd have employers in really early cases saying, well, I've got nothing against ethnic minorities, but my customers won't stand it. I can't possibly hire an ethnic minority member of my team. And it didn't really matter the fact that, the law was quite clear that that's not something you're permitted to do. You can't say, oh, but I've got really good reasons for why I should be able to engage in racial discrimination. And yet employers were still operating on this idea that they could lead with their gut. And it took case law having to be brought by employees or prospective employees to challenge the lawfulness of those policies. And eventually, the industry caught up. The thing that's making this difficult is that there wasn't really a concerted effort of a lobby group that was arguing in favor of racial discrimination, that was trying to muddy the water about, actually, you're right, you really are allowed to engage in racial discrimination if you've got really good reasons for it. And what we're actually seeing here is this kind of concerted effort. And then a lot of people being swept along. I think there's a whole bunch of lawyers who are kind of vaguely aware of the law in this area who now have strong views about this judgment. And you would never see this a really complex issue of tax law. Like you wouldn't have environmental lawyers thinking, I've got thoughts about that tax law decision. And yet they do have thoughts about this decision. They're signing open letters, they're doing things, and it's not within their field of expertise, but they have very, very strong views because it's a issue of public just debate and discussion and social justice, and so they feel like they're empowered to opine on it. So yeah, I mean, we're facing a unique set of circumstances when it comes to trying to get clarity on this area of law and then to get that implemented. But I think if anything has been shown, it's that if you piss off enough middle-aged women, the consequences are quite dire.
Hey, we're not all middle-aged. Some of us are pensioners now,
I'm sorry, I apologize.
and some of us are young. We've got more and more young people, young women coming forward. It is wonderful. So, yeah, but yes, on the whole, middle-aged, great. Anyway, right, let's see. Vicky, are you there? Let's get some questions from some of the members there.
Yes, I've got hundreds of questions. Apologies to people if I don't get your question in. So, the first question is, what does it mean for current tribunals like Sandy Peggy and the Darlington nurses?
That's a great question. I'm not as across the Darlington nurses case as I am across Sandy Peggy, but my understanding of the Peggy case is that in one sense, this judgment means nothing for that case because Dr. Upton does not have a gender recognition certificate as far as we are aware. And so, strictly speaking, this judgment doesn't have anything to say about this decision, about that case, and about a lot of these cases where these tribunals are dealing with policies that are based on self-identification, which has never been the law. And we've known it's never been the law. We've had case after case after case. So, in one sense, this does nothing to those cases because the legal rules haven't really changed. All the Supreme Court has done is clarified definitively at the apex level where the law is and where a lot of lawyers already knew the law was going to be. But in another sense, it's done something dramatically important at the level of the kind of political pressure that might be placed on these employers like the NHS. And so it may be that where they might have previously thought that there was a serious case to argue here and that there was a debate that could have occurred in a courtroom about whether it really is permissible to allow somebody like Dr. Upton to use female-only changing rooms, they're going to feel less confident about that now, I think. And that might push these cases into different areas. It might be that cases that are currently ongoing are locked in, they're not going to try and settle, but it may mean that cases that have not hit tribunals are going to start settling a lot quicker. I know that's certainly what's happened over the last year or two for some friends of mine who are in practice in this area, that a lot of their cases have been settling because employers are waking up to the reality that they actually have been engaging in unlawful policies for the last little while. And I think that's a good thing. We don't want to be having to crowdfund to for people to devote so much money and time and resources, and to usually women claimants having to drag themselves through this atrocious process in order to get justice. So I think it's good if they're settling. But the consequences are that we're going to see fewer of these cases, and sometimes it might be a good thing for us to have one or two of these cases so that the law is clearly articulated in these specific contexts as well. But yeah, overall, I think as a matter of law, this judgment, the Supreme Court judgment, doesn't actually affect the law applying to those cases because these policies are so clearly unlawful. You didn't need to have a Supreme Court talk about gender recognition certificates to identify that.
Yeah, great. Thank you. The next question is, can you comment on the claims that the court failed to consider the Human Rights Act and what the implications of that might be?
I'm very happy to do so. I've written a response to Crash Wigley's piece that I think is probably what people are thinking about here, which is currently with the editors of the UK Constitutional Law blog, which is where Crash Wigley published a kind of condensed version of that. So hopefully that will be published in the next few days, and that will go through in detail where I think Wigley went wrong. In brief summary, Wigley claims that the Supreme Court did not consider in form or in substance Amnesty International's arguments about the human rights elements here, and that is just not true. So you can point to several paragraphs in the judgment where the court expressly address these concerns about the human rights implications of this case, the human rights arguments in this case. And what the court says is the Gender Recognition Act has been affirmed at the European Court of Human Rights level to have met the obligation that arose from the Goodwin decision. There has been no case law at the European Court of Human Rights level that indicates that the right to gender recognition that's recognized in Article 8 of the European Convention on Human Rights extends to recognition in all areas with no exceptions, or that there would be a right based on that to gender recognition within anti-discrimination law. There's no case law to support that claim. And what there is case law that says when you are dealing with Article 8 claims as they relate to gender reassignment, so long as you have some system in place for obtaining state documentation, which is what the Gender Recognition Act provides, there's a wide margin of discretion afforded to member states for how they implement that. So if you take all of that together, the argument that there's going to be a successful claim under the European Convention on Human Rights, I think, is slim. I might even say it's manifestly ill-founded, which is a part of the test that the European Court of Human Rights relies on for throwing cases out before they even get to a full hearing. So yeah, I mean, I think, keep an eye out for a publication on that. I'll go through that in more detail. But in short, I think those claims that Wigley and others are making, I don't think they accurately represent what the judgment says about the human rights implications or the human rights context in this judgment. And I think they operate from this false presumption that Article 8 provides this entitlement, which there is no legal authority to say that it does. And so, yeah, I just don't think there's going to be a successful claim coming out of that.
Mm-hmm. Okay. The next couple of questions around the Gender Recognition Act. One is what are the implications for the Gender Recognition Act? And the other one is, are there any legitimate uses of gender recognition certificates now?
Okay, these are great questions. So the first thing to say is that this judgment gives us a clear test for when the Gender Recognition Act will apply and when it won't apply. Mm-hmm. And there is a very low bar that the court has set for when the Gender Recognition Act won't apply to an area of law. They say if construing the other area of law, the other statutes or the enactments, if a fair reading of those enactments would require you to interpret sex to mean biological sex, if it would be absurd for you not to read it as biological sex, if it would be unjust for you to read it not as being biological sex, then you have to read it as biological sex and you just disregard the Gender Recognition Act. And what that means, I think, is that in areas that we would ordinarily connote as being areas where sex matters, like strip searching by police officers or other areas where we'd be thinking about the rights of women might be engaged, the court has established what the test is for disapplying the Gender Recognition Act, and there's a low bar to meet in those areas. Areas where the Gender Recognition Act very much still will apply will be birth certificate registration, marriage certificates, death certificates. Those areas are clear. Things like pensions, there's a clear rule about pension, although that's less of a concern now because pensions have been equalized between men and women. But areas where we'll be thinking about state documentation and things like that, the Gender Recognition Act may have a stronger claim there. Ultimately, what that means is the legal effect of a gender recognition certificate effectively reverts to what proponents of the Gender Recognition Reform Bill said it was all along, which was a minor administrative document that allows you to change a few minor administrative procedures, and which they claim is a very important part of recognition of their dignity and their identities. That's all preserved, and that meets the obligations under the Goodwin decision under the European Convention on Human Rights. If you remove that, you then, repealing the Gender Recognition Act will remove the ability of courts to say we've met our obligations under the European Convention on Human Rights. And so then that opens up further questions down the line. So the two things that it does really is it locks in clear articulation in our law that the Goodwin decision has been met. The obligation that arises out of the Goodwin decision is met. We no longer need to consider what the UK as a state has to do to meet that obligation. The Gender Recognition Act meets that obligation. So these further arguments kind of fall away. And secondly, what it does for people with trans identities is it provides them with those documents and administrative things that meets their rights under Article 8 of the European Convention on Human Rights. And what the judgment has done is it's basically said there's now a barrier for the legal effect of those gender recognition certificates in any area where it's plain that the rights of women or others would require a biological definition of sex. So I think this judgment has placed the Gender Recognition Act in its appropriate legal context, in a way that recognizes both the rights that trans people will have under the convention that's recognized by the European Court of Human Rights, without allowing that to unduly interfere with the rights of others, particularly women and sexual minorities.
And somebody's commented in the chat that by changing birth and death certificates, it makes a huge difference to statistics and then leading to effect on social policies and so on. So there may be an impact in allowing those things to happen.
Yeah, I mean, one of the things that we've seen with the data bill that's been going through is that the government seems to be operating on a presumption now that it will be able to clearly differentiate the kinds of documents that provide information about biological sex and the kinds of documents that don't. And official statistics where they're trying to capture information about biological sex won't be able to go to information where what's being provided is not an accurate account of biological sex. Now, for birth certificates, the birth certificate registry will still have someone's sex as registered at birth. Their biological sex will still be on that registry. It's just that there is another version of the birth certificate that you can get that has the certificated sex version on it. So it could just be that when statistics are being done, they will have to go back to the records as they are unmodified to pull through information on that front. That's the kind of stuff that I think would require statisticians and those who are doing that kind of work to pay careful attention to whether or not the information they're drawing is information about certificates or information about biological sex.
Yeah.
But I don't think there's anything in this judgment that would impede them from being able to do that. It just comes down to whether they've got good practice in that area, I think.
Sure. Okay, thanks. The next question is about the data bill going through Parliament at the moment and the self-ID element of that, and asking for your comments on that.
I suppose what I'll say is just that this is in flux at the moment. I mean, I think people may have seen that there's been some amendments that have been accepted in the House of Lords that may change the way in which this bill is enacted. We've seen some comments from the government recently where they've, I think it was yesterday or the day before, where the government has indicated that it will not allow you to verify biological sex where biological sex is what you're required to verify, with reference to any source of information that doesn't contain accurate data about biological sex. Now, one of the issues is where are the data sets where we have accurate information about biological sex. That's a harder thing to identify. I'm not as across that kind of, sociological data information. I think, someone like Alice Sullivan would be very good to get talk about that side of things. But I suppose the comment that I have about the bill at the moment is that it's in flux, and we have to wait and see what the House of Commons does with these amendments that have been approved by the Lords. So the procedure will be that this will now go back to the House of Commons. The House of Commons will have a chance to decide whether or not to accept the amendments that the Lords has proposed or to reject them again. And then you can have this kind of ping pong for a little bit of time. But I think I just have to wait and see what the bill looks like at the end of that process before I can comment any further.
Sure. The next question is about, you talked about different lawyers having different interpretations, and somebody's asked, how can lawyers advise incorrectly? Isn't that negligence?
So there will hit a point where that will become negligence. There's two issues with that. I mean, the first is that there's some things that lawyers might say about this judgment that will clearly and unequivocally be wrong, and any lawyer who is a qualified lawyer who has gone through the processes will know. So if there was ever a lawyer that stood up and said the judgment isn't law yet, that would clearly be providing inaccurate legal advice, and I think that would raise the level of negligence. But there will be other areas where there is a genuine point of disagreement, legitimate disagreement. So it is unequivocal that the Supreme Court has said that you do not have a legal entitlement to use single-sex services intended for members of the opposite sex. Mm-hmm. There is a gray area about whether or not choosing to provide a trans-inclusive service is unlawful. Now, I'm of the view that if you don't have the exceptions that protect you under Schedule 3 of the Equality Act that allow you to apply single-sex services, you expose yourself to pretty steep liability if you have trans-inclusive services, because they can be discriminatory on the basis of sex, and they may also be discriminatory on the basis of belief. And there's there's a whole bunch of arguments about that. But that's in a slightly grayer area where lawyers might reasonably disagree on that, and you're not going to rise to the level of negligence on that front. And then the third point to say about this is that one of the real problems that we have with professional negligence is that there's a protection built in most legal systems for protection for professional negligence that says, well, if everybody in the profession was making this mistake, we can't target you. Like, it was fair for you to make the mistake. And so if there's enough people making these mistakes, it's harder for you to sue somebody for professional negligence. And unfortunately, in the aftermath of this judgment, there are an awful lot of solicitors that are not really experts in this area making these mistakes. So that makes professional negligence claims harder. But I mean, I'd be quite interested to see if anybody knows someone who's an expert in professional negligence, just where this barrier or this boundary is, because I think, there very well might be some lawyers who are exposing themselves to professional negligence. One of the difficulties with that is that in order to bring a claim for professional negligence, you have to have relied on the legal advice that lawyer has given you to your detriment. Mm-hmm. So if you know the advice is bullshit and you don't rely on it, you can't then sue the person for professional negligence. It's only if you've relied on it to your detriment. And normally organizations that rely on this advice to their detriment don't want to sue their lawyers as a result of it, because they tend to be in agreement with the politics on one side or another.
Yeah. Sure. Okay. So the next question is, the Supreme Court commented that it might be proportionate to exclude a trans man when that person's appearance might cause distress. Some people say that means that trans men might now have no spaces, being excluded from male spaces and female spaces. Do you think the Supreme Court comments were intended to apply narrowly to things like rape crisis, to those sorts of things, or is this a real issue for trans men?
My view is that the Supreme Court's comments were intended to be applied narrowly. I think what they were saying was that this is one of those areas where there very well will be required to be a case-by-case analysis, because just how medicalized you are, just how much you look like a member of the opposite sex, just how much distress is the kind of distress that would make it proportionate to exclude someone, and what space we're talking about. These are all variable questions that would require you to think carefully about how they apply in particular contexts. That's different from thinking about the proportionality of a clear sex-based rule, because you can identify rules that could justify, or reasons that could justify, a clear sex-based rule that will apply in any circumstance where you're excluding a male person from a female place, or vice versa. Whereas you couldn't say you can have a blanket policy of excluding all female people who identify as men, because that will clearly be unlawful. So what the court has said is that there may be some circumstances where the medicalization process that a trans man has gone through gives such a convincing appearance of being male that it may be proportionate to exclude them. And I think what they had in mind was a rape crisis center, or areas where maybe, changing rooms or things like that. That does not mean that there isn't an obligation then to try to find a reasonable accommodation for the person that you have excluded from the service that they would, had they not medicalized, had an entitlement to use by virtue of their sex. And so there will be a need to push for more accessible options. and an awful lot of service providers will have those available. And there may even be circumstances where, let's say you've got, it's a pub and you've got a male toilet and a female toilet, and you don't have an accessible toilet, and it's lawful for you not to have an accessible toilet because it would be too expensive for you to install one. Well, one thing that could happen in that circumstance would be that if a trans man who didn't feel comfortable going into the ladies, but knew they didn't have a legal entitlement to use the men's, they could approach a manager or someone who's involved in there and explain their situation to that person. And then they might say, oh, that's fine, you can use the staff toilet. Or, you know what, that's fine. What we'll do is we will put a sign outside the door to ensure that nobody else goes into the female toilets while you're using the female toilets. You can use the female toilets, and then when you are done, we'll take the sign away. That's one way to accommodate an individual in those circumstances. Of course, the practical problem is that people are often not pointing to this gotcha question because they genuinely want a solution that can accommodate the trans person. They want to point to that as a way of saying, see, the judgment creates this serious problem, and this is why you should be just using toilets or changing rooms on the basis of self-identification. And one simply does not follow from the other. I mean, the fact that there may be a genuine problem for trans men who pass doesn't mean that you then collapse the entirety of the protections that women have to single-sex spaces, for example. It just means that you will have to accommodate that person if it's at all possible. And it might be the case that it isn't possible, at which point, there's a point at which the law says, terribly sorry, but it's not unlawful for them to deny you service. In the same way that, not every pub is going to be able to have an accessible toilet for disabled users. And the reason why they might not be able to have that is that the law has said there is a threshold requirement for reasonable accommodation for disabled people, but it doesn't require you to bankrupt yourself in order to provide that accommodation. And if you've crossed into that threshold where it would not be reasonable to expect the service provider to provide an accessible alternative, then it's really unfortunate for you, and we're sorry that you don't have facilities to use there, but that's where the law has come down. It doesn't provide an absolute entitlement to those services, and it doesn't make it illegal for a pub to operate even if it doesn't have an accessible toilet. So that's just the harsh reality of trying to manage really difficult questions in the real world, is that sometimes it creates problems. And I mean, I have a lot more sympathy, I think, for people who have, by virtue of becoming disabled or being born disabled, but not through any choices of their own, are finding themselves excluded from pubs or other areas because it's just not feasible to require accommodation. There's a sense in which that situation is different from somebody who has chosen to medicalize. I mean, I understand from the perspective of those who've chosen to medicalize, often they will say, this is something I just couldn't avoid, I couldn't help. But we're seeing, a lot of times now where people are not saying that. They're not saying that I would have been so woefully distressed if I hadn't had this. They just say, this is a choice I've made for myself, for my body. I've decided that I want to do this because I'd feel more comfortable doing that. And that might result in you having fewer facilities available to you than you might otherwise have had. And the perspective from the law is that that's a shame, but it's not illegal.
Great. Okay, thank you. The next question is about Parkrun. Parkrun is a free 5K race. Will the ruling have an implication for Parkrun, which encourages self-ID and means that many female records have been taken by male-bodied runners?
Yeah, the judgment spoke about sport. So it had paragraphs specifically about sport. It said the provisions relating to sport don't make sense if they're not operating on the basis of biological sex. The judgment doesn't expressly say that sporting organizations aren't allowed to do mixed sex competition. It says that they are allowed to do female-only competition, but the reason why they're allowed to do female-only competition is to ensure fairness or safety. I mean, in Parkrun, we'll be talking about fairness. So because if you're operating anything here on the basis of self-identification or something that is not on the basis of biological sex, the exceptions in the Equality Act begin to fall away. They don't quite fall away with the sport exceptions, because the exception says that you have an exception that permits you to do anything in relation to sex discrimination if it relates to participation in sport, in a competition.
Can I jump in here, because the parkrun example is something quite different, because first of all they say they're not a race.
Mm-hmm.
And changed all the record. They removed the records after we had a long year-long campaign against them, and now they're saying they're not a sport. So they are a community
of people who flourish along particular. They
yes,
just frolic
they
along.
get together and you meet
Right.
the community and you work up a sweat. So
Right.
they're looking at, even though they get millions from Sport England. That's their argument. That's why they won't be changing until somebody, they're forced
Yeah.
to.
I mean, there may be litigation coming there. I mean, my view is that the sport exceptions are weird. On the face of them, the provision section 195 says that you are immunized from any form of sex discrimination where you are dealing with participation in a sport that's gender affected. Now, if Parkrun doesn't want to describe itself as a sport or as gender affected, then they don't get to rely on the section 195 exception. But I think if litigation occurs, they're going to try and rely on section 195. Section 195 is very broadly worded. It says you can do anything in relation to sex discrimination when it comes to participation in sport, as long as it's gender affected. And that creates a real counterintuitive implication. Because what it would mean if you just took the literal words, which I don't think a court will do, but if you just took the literal words, that would mean that a coach deciding whether or not someone could participate in a sporting event, if he said a condition for participating is if the young female athletes are willing to sleep with me. Now, that would ordinarily be sexual harassment and sex discrimination. But both of those are covered under anything done in relation to sex discrimination as it relates to participation in the sport. So if you took a literal reading of that provision, it would immunize that kind of behavior. Now, that's ridiculous. There's no way that a literal reading will be taken there. So they'll have to think about what the purpose of these provisions are. And the purpose of these provisions is to preserve the integrity and the fairness of female sport. Mm-hmm. And so the question will become whether or not failure to do that, failure to rely on them, exposes you to liability for discrimination. Look, my view is that actually the sporting provisions are weird, and that means that the cases they're not as clear cut as some of the other cases might be. I think we're waiting for proper case law to come from this. I know we've got a case ongoing about pool at the moment, but I think we really need to wait for cases in order for us to really understand exactly where courts are going to start drawing the line on that, because the provisions seem extraordinarily broad in terms of what they protect. And that can include sex discrimination by having mixed sex events that put women at a disadvantage.
Brilliant, thanks. I'm going to hand back to Heather now for the final few minutes.
Yeah, my goodness, that was full on, and there are plenty more questions in.
Sorry, I rambled a little bit long on some of those questions.
It was really interesting. You didn't ramble at all, and neither have you fallen asleep. So I'm pleased at that. So I've got one here because we've been working on a report. We had been collecting data from around the country about the chaperoning in the NHS, because we know a number of men identifying as women have been allocated chaperone roles. And of course, we've changed the focus of it since the Supreme Court judgment. So it will be very different. But one of the questions from that group that are looking at that have said it'd be good to understand how privacy of a trans healthcare worker, concealment of their sex, can be maintained in a hospital situation where staff are expected to chaperone at short notice. If hospital policy is to record a member of staff as their self-described gender, how can chaperone policy? Well, that in the light of the NHS statement, that might.
Yeah, I mean, I think there's 2 points to be made about that. I mean, the first is to say that the NHS looks like it's beginning to change its policies on this anyway. But if we're thinking just about the law, the right to privacy, the human right to privacy that's often relied on here is a qualified right. It's not absolute. It can be legitimately interfered with in circumstances where it's fair and where the rights of others might be engaged. It's not even clear whether the right to privacy includes a right to hide your sex. A lot of people are presuming that it does, and the right to privacy is broadly construed, so it might be engaged in those areas. The legal tests are, when we're dealing with things like this is normally called the misuse of private information court. It's a particular kind of legal case that we're dealing with. The 2 questions that have to be resolved are, firstly, whether there is a reasonable expectation of privacy in this context. And I think it's going to be very hard to establish that it was reasonable for a trans healthcare provider to expect to be allowed to keep that information private if the consent of female patients depends upon maybe not knowing that person's sex, but certainly respect being given to the consent condition that they have put down. It might not necessarily confer an entitlement for you to know the sex of everybody who's working in the hospital, but you should be assured that if you say you wanted female-only care, that's what you get. I can see a human rights violation occurring if you have been promised female-only care and you do not get that. I've got a chapter on this in my book that I'm hopefully going to be finishing over the summer, which will be out hopefully early next year, which is going to be on the law and sex and gender identity. But
no kidding.
What was that? Oh yeah. It's going to be about tax law. Actually, that's what I've been really working on, is the tax law. This is just like a side project of mine at the moment. But yeah, look, the short and simple answer is that I don't think there is a right to keep your sex private in contexts like that, which means if there is a legal wrong done to a woman when she requests single-sex intimate care and it is not provided to her, then she will be able to sue. And I don't think there will be a compelling justification or defense that's grounded in the privacy of the individual who's seeking to keep their sex private. There may be rough areas where we have to kind of work through how that practically operates, where somebody they shouldn't be required to go into a patient's room and say, just so you know, I'm really male. There may be privacy concerns there, but what you have to be able to guarantee is that if a patient has requested single-sex intimate care, or single-sex care, doesn't have to be intimate care.
Yes.
And she is told that she will get that, then that's what she should get.
Okay. That's great. Thank you very much. I'm not going to hold you up any longer. It's been absolutely fascinating. You've talked well. You deserve a whiskey or whatever your tipple is.
Oh, I'm going to my bed. I'm exhausted.
Well, go to your bed. It's still daylight, very much daylight up in Scotland.
Yes.
Thank you very much on behalf of everybody here. We're so grateful for all your hard work, for everything you've done. We're looking forward to the book coming out. We'll get you back again.
Anytime.
Lovely.
Happy to do it, guys.
And I'm sure it'll be before your book comes out, but when your book comes out also, that will be fabulous.
Absolutely.
Anyway, Thank you very much. I love going to your lectures. I wish I was one of your students. I do.
Oh, that's really kind. That's very sweet.
But thanks very much. Won't hold you up. Go to bed now. Okay. Thank you everybody for joining us.
Bye everybody. Thank you very much.
Thanks. Okay. Bye.
Bye.